Hello, beautiful people, and welcome back to my channel. It has been a minute, so I hope you all had a wonderful holiday season and a great start to the new year out there in this notary world. If you are new here, my name is Natalie Gaiman, and I am the owner of NGC Mobile Notary Services in Tallahassee, Florida. Thank you very much for watching. Please like, comment, and subscribe if you find something in this video or on my channel that you feel is helpful. If you've been riding with me for a while, thank you very much for watching and welcome back. So today we are going to be doing another video in our Mastering Notarization series. This example that we're going to provide today is a dual power of attorney. Um, and if you do estate planning, or if you um, have been fortunate or unfortunate to be someone's power of attorney, you know that this is a very, very legal document that a lot of lawyers and families go to ensure that their loved one has someone who is able to make those decisions for them. So, a doable power of attorney provides a signer, who is the affiant or principal, the ability to give an agent or their person who they choose the ability to make healthcare and medical decisions for them. This is very needed because if you just have a standard power of attorney, once that person becomes incapacitated, that power of attorney no longer is valid. With a durable power of attorney, if the signer becomes incapacitated, then the durable power of attorney is still valid and still intact, and therefore the agent can go ahead and ensure that the principal or the signer has all of the medical necessities and under and knows that their family member is going to be taken care of. So that is what we're going to be doing today. Usually I give you a physical presence example and a RON example in the same video, but today I'm just going to give you a physical presence video. I'm then going to come back and do a RON video regarding the same example. So let's get right into it with the physical presence doable power of attorney example. Here we go. And we are back. So here we are. Here we have our Florida doable power of attorney. And let me preface this by saying that I am in the state of Florida. You would follow your notarial laws or your laws regarding your state regarding completing this document. I don't know if everyone's state allows them to complete this document. So, of course, this is going to be Florida specific. But regarding the notarization, you can use it in order to help you in these type of documents for your state as well. So here we have the blank one here where it is not filled out here. So in Florida, this is just a generic one that they can get offline if they Google doable power of attorney here. So this is one that they will get here. So this is the blank one here for you. There are some particular like hospitals and facilities that have their own or created their own, but this is just a generic one. So that is the blank one. Now, this is the completed one. As you see, this is how long I have been trying to complete this video. So this was done in physical presence. I got some individuals in order to help me in order to fill this out. Okay, so of course, at the top, the date that you are completing this form, this is when you're going to put the date and the year. Here you have the signer or the affiant or principal who is going to place their name here. And then it just wants to know the city where they live and the state of here. Then it says hereby designate. Then you're going to put the person who they are going to be providing as their agent. Their name goes here. And then you're going to put Tallahassee or whatever city you're in state of. That's that information there. Next, down here, so that's that information, the state excuse me, the city and the state of where they are. And this is just stating that they are um, designating this person as their attorney of fact to do all of the information that they initial below. Now, the next section is the effective date. This says choose the applicable paragraph by placing your initials in the preceding space. So you have two options, and you're only going to choose one here, or the applicant or principal is only going to choose one here. You have number 8 where it says, I grant my attorney of fact the powers set forth herein immediately upon the execution of this document. These powers shall not be affected by any subsequent disability or incapacity I may experience in the future. So, like I said in the beginning, this lets the agent continue even if the principal becomes incapacitated to continue their duties based off of the information that has been linked to below. Now, B says, I grant my attorney of fact the power set forth therein only when it has been deemed in writing by their attending physician that they're unable to properly handle their affairs. Now, you may be asking, which one do most people choose? Most people choose A. And the reason they do that is that even if they're still able to make their decisions now, just in case anything happens, they want to go ahead and say, hey, let's do this immediately, even though I know Jane is still able to make her decisions, but she's in a nursing home. So if I need to go to the bank to get money out, or if I need to talk to Medicaid, Medicare, anything like that, I'll already have this document here able to assist me in what I need to do for her. So that's the effective date. So next, you have the section where it says power of attorney in fact. And this is where the principal will go down and they will initial which items they give the agent the powers in order to do. Most of the time, everyone initials each one just in case, but there have been times where the principal has only initialed the ones that they feel are needed because the other ones aren't applicable. Now, for the ones that they leave blank, they can put NA on, of course, which means not applicable, to let them know, say, hey, the agent doesn't have these powers because they're not applicable to me at this time. I've had that happen a couple of times, but most of the time it's only been everybody fills out everything. So these are the different powers that they give. They give banking, safe deposit box, lending or borrowing, government benefits, retirement plans, taxes, insurance, real estate, personal property, power to manage property, any gifts, legal advice, and proceedings. Then we get to special instructions. If there were any special instructions, let's just say that the principal wanted to name 2 people as their power of attorney. You could also place that individual's name here and just say, I also give powers in conjunction with the name listed above 2, and put that person's information here. Of course, just like they did at the top, you will put their name, you will put the city where they're from, and their state. And that could go in special instructions. Or if there are no special instructions, just like here, you will put none, like we did here. Or you could also put NA for not applicable as well. And then you have your authority of the attorney in fact, and then just provides these legalese here at the bottom. Then it just states that photocopies of this document can be relied upon as those were their originals. Now, that is what I always tell anyone who calls me and I complete a power of attorney for them. I tell them to please ensure that they can keep the original, and that it does state that you can make copies if need be. So then here we are. We have in witness of, this is the date that it was completed. And then we have the principal's signature here. Of course, as always with anything, let me go down here. So as you see, 2 witnesses are required, and the witnesses cannot be related to the signer. It cannot be her daughter-in-law. It can't be her daughter. They cannot be related, blood related at all, to the signer. As always, I forgot to mention in the beginning, we are going to ensure that our signer understands what they are signing. So before we can even get to that part at the top where they fill in anything, what we're going to do is that we're going to verify our signer's identity. We're going to make sure that our two witnesses are there, and then we're going to get everyone's ID that is there is what we're going to do. That's what we're going to do first of all. That is notary one-on-one. You go in, you greet yourself, who's our signer, who's our two witnesses. May I see everyone's ID and ensure that no one's ID is expired. And if the ID is expired, make sure that it has been issued within the last 5 years, at least for Florida. This is what Florida allows. If your ID has been issued within the last 5 years, you can use that ID, but if it's beyond that, then you cannot use it. And of course, we wouldn't be able to complete it unless they found another witness or the signer get an updated ID. So once we have verified everyone's ID, I then ask the signer. I asked everyone to step out of the room, and I asked the signer, Miss Doe, I just want to assure that you are understanding what you're signing today. And then I asked them what they're signing. Then I asked, are you signing this document of your own free will without any persuasion for anyone else? Now, if they ask me, oh, can you ask such and such to come back in, or looking around for someone to answer them, then of course I stop the appointment at that particular time and let them know that unless you're able to provide me this information without help, then then we can go ahead and continue. But without them understanding, I don't feel comfortable moving and stamping this document. Now, once they tell me, yes, I understand, I understand what I'm signing, and I'm signing of my own free will with no persuasion from anyone else, then I'll ask everyone to step back in the room, and then we can continue from there. So I apologize. I should have said all of that in the beginning of the video. I was just so anxious to get into this document today. I apologize. All right, so we have the signer here and the principal, so they've already signed their information. We have our two witnesses who provides their signature, their printed name, and their full address, which includes the city, state, and zip code. This is what Florida requires here. We also have our second witness who has her information listed here. Now here is my notary block. Of course, we have our venue, so I'm going to put that I was in the state of Florida in Leon County. Of course, we were in physical presence. This is the date that the document was completed. This is the principal, what type of ID she provided me. I signed my name, printed name when my commission ends, and here is my stamp. That document for that part of it is now complete. We have all points that are needed for the state of Florida, and this document is notarized correctly. Now, down at the bottom, this particular power of attorney, it also ensures that the agent or the attorney in fact also understands their appointment. So then therefore they have to sign as well. So they're going to print their name here. So you see John Doe. He's stating that, yes, I understand what just happened. I understand that I am going to be Jane Doe's attorney of fact. So then he signs here. Then we have our venue again. So we have the state of Florida, Leon County. We have that it was done in physical presence, the same date that it was completed. We have the agent who's now signing, the type of identification that they provided me. Once again, I signed the document, printed name, commission number when it expires, and my stamp. Now, what we do from here, everything is complete. But as always, we want to go over and make sure that all the document is complete. Make sure everyone's missing. Everything is checked the way they do. So we're going to go back up from the bottom. And we're just going to make sure that everything looks correct based off of the way that it should do. Make sure that everything's initialed. Make sure that there's nothing missing. Okay, as we see, the document is complete. So we can let the signer know or and her family know, okay, Ms. Joe, here is your document. It is now complete. Um, and make sure you keep it in a safe place where you need it. Ask them if they have any questions. And then if they say no, I don't have any questions, then you're good to go at that particular time. You can go ahead and hand them the document. Make sure that, of course, they sign in your notary journal. Make sure the witnesses sign as well as the principal sign, as well as the agent sign, since it does have that for all four individuals on the document. Make sure that your journal is fine. I understand that in Florida, a journal is not required, but it is recommended. But just in case someone calls you, because I did have what I completed a power of attorney and someone called me because someone challenged the power of attorney, and so I had to go back into my journal and say, hey, this was the date that I did it. This is what happened. These are who the witnesses were. And I had to provide them that information, and I had to complete an affidavit because of the person who was challenging the power of attorney and the validity of the power of attorney. So once they sign that, all of that, make sure you receive your payment about whatever your payment is. That notary assignment is now completed, and you have completed your service and done your service, and that is how to complete a power of attorney, excuse me, a durable power of attorney via physical presence. All right, everyone. So that is the end of this video for mastering notarization, the durable power of attorney physical presence. Let me know down in the comments. Um, and I'm pretty sure we've all have done doable power of attorneys. But let me know. Were you scared when you did your first one? Do you do them often? Because I know some people just do estate planning. Some people just do general notary work. I know I have one notary friend where he has a contract with a company that sends him to different rehab facilities in order to do doable power of attorney and qualified income trust. So let me know down in the comments what you guys have done before. Were they easy? Does your state allow you to do these? I really, really love interacting with you guys. Also, put down in the comments what would you like me to notarize next as an example. All right. Well, it was nice talking to you guys. And as always, I will see you in the next video. And until the next time, happy stamping and signing.